Hello everyone. This is part 2 of our discussion on compulsory licensing. So as I'd mentioned in my part 1 of this video, we'll discuss about some of the remaining provisions of compulsory licensing and also discuss the questions that have come in the previous year's question papers regarding compulsory licensing. So section 92 provides special provisions pertaining to compulsory license where a central government may notify that a compulsory license is available for grant in respect of a patented invention where there is a case of a national emergency or maybe an extreme urgency, or if there is a public non-commercial use that is required for benefiting the public. So it is more in the public interest that the government gives that notification and declares that a compulsory license may be granted on a patented invention. Once there is a notification like that, any person interested can file an application for grant of compulsory license. Upon filing of an application for grant of compulsory license, all the provisions that we have discussed in relation to section 83, section 87, which is the procedure based on which a compulsory license is granted, section 88, section 90 are applied, and the same process goes through for consideration of a grant of compulsory license in respect of these special provisions. While granting a compulsory license under section 92, the controller has to ensure that the terms and conditions under the license are able to ensure that the patented article is available at an affordable price, while also protecting the patentee's interest that he should be able to obtain some reasonable royalty out of the compulsory license. Further, in case the central government feels that the national emergency or the extreme urgency is in case of issues such as AIDS or TB or malaria or any other epidemic, something like the coronavirus epidemic, then the procedure under section 87 may not be followed and the controller would directly issue a compulsory license. But this is only in extreme cases of public health crisis. Further, section 92A provides that a compulsory license could be granted for export of patented pharmaceutical products. So this is pertaining to a specific type of patented product only. So the compulsory license is granted for the purpose of manufacturing and exporting to a country which does not have sufficient manufacturing capacity in the pharma sector, and that country is facing some health problem which is addressable by the patented pharma product for which the compulsory license is being granted. Also, the country should have allowed importation of that patented pharma product from India. So there should be a specific notification in that regard by that country where you are planning to export the patented pharma product. Also, while granting the compulsory license, the controller ensures that there are terms and conditions which limit the export to only that country. So this is a very specific compulsory license for a patented pharmaceutical product for catering to a specific market in that country. So these are additional provisions that you need to take care of when answering questions. I've seen that there are certain questions at times which relate to export of a pharmaceutical product. So in those questions you need to take care of all these provisions. So let us now discuss the various questions that have come in the question papers, and we'll discuss all these provisions in detail while answering those questions. So this is a question paper of paper 1 2008 April. Here there is one question of 5 marks and it's a very straightforward question, part 1F, which says that state the grounds for grant of compulsory license. So this is what we have studied in section 84. This elaborates the grounds that are there, and then it straight away asks you what is section 92A of the Patents Act. So if you recall, we just now discussed section 92A, which provides for compulsory license for the purpose of exporting to a country which has insufficient or no manufacturing capabilities in respect of a patented pharmaceutical product. So you need to take care of all these keywords while answering this question. Then comes the question paper of 2008 December, paper 1. There is again a question regarding compulsory license, and it says enumerate the provisions relating to compulsory license for export of patented pharmaceutical products. So this is not a straightforward question. So here what you need to discuss is section 92A, that's for sure. Apart from that, if you would recall, section 90 also provides terms and condition for grant of compulsory license. So if you would see, section 90 provides under subsection 1 and part 7 that the license is compulsory license is granted predominantly for the purpose of supplying in the Indian market, but the licensee may be allowed to export if it is required to serve the purpose under subclause 3 of clause A of subsection 7 of section 84. So let us see what that says. So if you see, this is the provision that is being referred to. It says that the reasonable requirement of the public would not be deemed to be met if there is a market for export of the patented article and it is not being supplied or developed with. So if this is the condition, then also export would be allowed. So here you need to mention about section 92A and also the conditions that are provided under section 90. So now this is paper 1 of 2010. There is a question. Again, it relates to section 92A. It asks you what an Indian generic company needs to do so as to export a drug which is patented in India to Nepal. So it needs to apply for a compulsory license, that's for sure. And that is to be done under section 84. That's the process for applying for a compulsory license. That's one. The other thing is the government of Nepal should issue a notification on public health grounds, and only then you fall under section 92A for the purpose of exporting to Nepal. So these are the two solutions which are required to be carried out by the Indian generic company. Then there is a question 14 which says that A was granted a patent on 1/1/2006, and then there is a party B which infringes the patent, which was restrained by the court of law on 1/10/2008, and after 2 months of this, the party B applies for a compulsory license. So whether B would succeed to get a compulsory license or not. So now here if you see, 2 months from this date is 1/12/2008, and a compulsory license is only granted after the expiry of 3 years from grant. So in my opinion, the 3 years from the date of grant is not complete, and thus the answer should be no compulsory license could be granted, because it has to complete 3 years, and after that only one could apply for a compulsory license application. However, in case you have any other thoughts on this, please share those in the comments box. It would be good to have your insights on this particular aspect. So again, there is a question. This is under the same question paper, and this is part B2 of the 2010 paper 1, and this is the question. It just says that the patentee is unable to supply the required volume of the wonder drug in India during the crisis of malaria. So now malaria is a keyword here. There is a company which has approached Larva Limited, which is the patentee, for a license, but the license has been refused. So now what are the options that the company has? So here you might think that since there is a discussion about malaria, what about applying section 92? But that would apply only when there is a notification that has been given by the central government. If there is no such notification, then what's the case? Then you need to apply under section 84. You can apply for a compulsory license on the grounds that the reasonable requirement is not being met. The patentee is unable to supply the required volume of the wonder drug to the market during this crisis. So this could be a reasonable ground for grant of compulsory license. So in your answer, you can provide that under section 92, compulsory license could be requested for if there is a notification by the central government, or otherwise the normal procedure under section 84 may be followed. So this is a question in the paper of 2013, paper 1, part B. It is a straightforward question which asks you the grounds to make an application for grant of compulsory license under section 84(1). So you need to specify all the grounds and what is the process, and it also asks you what are the factors that the controller is required to take into account while considering an application. So here you need to mention the provisions under section 88 and section 90, which provides the terms and conditions that need to be there in a compulsory license, and section 88 provides the power of controller while granting compulsory licenses. Here you must also specify what qualifies as the reasonable requirement having not been met. So you need to also specify what are those conditions. Then there is a question in 2016 paper 1. This is a true and false question, question 36, which provides two situations whether or not these are true for grant of compulsory license. I'm not reading through the entire thing. Maybe you can read through it and compare it with the provisions under section 84, and you'll find that both of these should be true for a grant of compulsory license. Then this is paper 2 of 2016. Here there is a question which is not a direct question. It says that Y has an Indian patent and X requests for a license under the patent, and Y imposes certain conditions. So these are restrictive conditions that have been posted. Licensor imposes a condition of exclusive grant back. So now all these are keywords that you would recall are provided under section 84(7), where reasonable requirement is not deemed to have been met. So here you need to advise your client regarding this question. you can always rely on the provision of section 84 subsection 7 to say that he can request for a compulsory license based on these facts. In the paper of 2018, paper 1, there is a single question about section 92A. So you might have noted that this is a very important provision. It asks for what type of product is an export available under compulsory license. So here you know that this is only a pharmaceutical product. So this is the answer for this particular question. So one question which I have kept for the last is 2010 paper 2. So your client is a potential licensee who wants to sell a particular patented device in a particular market, and he's asking for your advice regarding a potential licensing deal. So here basically it relates to licensing of patent rights, and you may have to advise regarding section 140, which relates to certain restrictive conditions that need to be avoided in any type of license or contract for a patented article. But here you can also bring in the aspect of compulsory license, that in case the negotiations fail, then your client could always ask for a compulsory license on the ground that a particular market is not being supplied with, or he needs to satisfy the criteria that the adequate requirement of the public is not being met, and based on that he can apply for a compulsory license also. So the aspect about compulsory license becomes an additional advice in respect of this particular answer. So basically you'll be providing him detail about the licensing aspects, what needs to be taken care of, and regarding registration of the license before the patent office. Also you can bring in the aspect of compulsory license in this particular answer. So this is all about the provisions related to compulsory licensing. If you have liked the video, please hit the like button and subscribe to the channel so that you get regular updates regarding the videos that I'll be posting regarding preparation for patent agent examination and also the various provisions of the Patents Act. If you have any questions regarding what we have discussed, please write those in the comments box and I'll be happy to answer those. If you have any suggestions regarding the topics that need to be covered, please do write to me about that. With this, I'm ending this particular session. Thank you very much for your time.